So good morning, everybody. Welcome to this session for EU law. And this week, we have the pleasure to be joined by Dominique Grieve, that I don't need to introduce to you anymore, and by Dimitrios Giannopoulos. They will be discussing with you broadly the outcome of the negotiations between the UK and the EU, but more specifically, the future of the relationship, the new relationship that has been negotiated by both parties, and what this relationship now looks like between the UK and the EU. And the overarching theme for the session will be justice. So we will start with Dimitrios, who will tell us a little bit about the European arrest warrant and what's happening to this mechanism. And then Dominique will follow on with the broader aspects of judicial cooperation. And Dominique will also say a few words about what it means to be outside of the single market from the point of view of trade and from the point of view of culture. So thank you very much both to be joining us today. And I look very much forward to what you have to say about both these topics.
Thank you very much, Virginie. It's wonderful to find everyone here, the year 2 students who I have heard. I was incredibly flattered. I have expressed an interest in meeting, more frequently, or a complaint that we were not meeting so often. They were not meeting me so often this year. The reason being that my academic or intellectual focus is on subjects that we mainly cover in year 1, such as criminal practice and criminal justice and criminal law, and similarly in year 3, criminal evidence and aspects of human rights. But on the other hand, what a privilege I'm given today to be here to teach you in such wonderful company. And that must be my starting point. It goes without saying to thank you, Virginie, for your invite, and Dominic, to thank you for your continued support. You have so consistently contributed to our program today that I must start by thanking you once again for your invaluable contributions. Area of freedom, security, and justice, to use the technical term, which was originally excluded from the EU's legal jurisdiction, and where the EU has only gradually developed shared competences with member states. By shared competences, we mean that the EU is able to legislate and adopt legally binding acts along with member states. Member states can exercise their own competence only where the EU does not exercise or has decided not to exercise its own competence. To trace the origins of the European arrest warrant, we must more specifically go back to the Treaty of Amsterdam, 1999, which established the area of freedom, security, and justice between member states, which aims at ensuring the free movement of persons within the Union, offering at the same time a high level of protection through judicial and policial cooperation, common asylum and immigration policies, and a concerted effort to fight transnational crime. The faster borders within the EU began to crumble and citizens or corporations began to exercise their freedoms to work and reside in other member states and to move freely or move goods freely between member states, the more urgent it became for EU countries to work together in the face of criminal activity that was crossing member state jurisdictional lines. Serious organized crime is often committed across borders, as you know. So to prevent safe havens for criminals, EU countries' laws had to be more aligned in order to face the problem of organized crime and other types of criminality that was being committed across national borders. The 11th of September attacks in the US that drew attention to the necessity of carrying out an effective war against terrorism at global level gave this process further momentum. As a result, the European arrest warrant legal instrument was adopted by means of the framework decision on the European arrest warrant and surrender procedures. Please make a note of that. I will also provide some notes after this lecture. Is the framework decision on the European arrest warrant and surrender procedures between member states of the European Union that was signed into law on the 18th of July 2002. At the same time, the gradual development of criminal justice measures that could gravely affect citizens across member states created the need for common procedural standards, similar to the ones that we studied together in our criminal practice lectures last year, for instance. The right to liberty, the right to legal assistance, the right to silence, the presumption of innocence, to take a few examples. Common procedural standards would increase people's confidence in the fairness of proceedings, knowing that their rights would be protected when they would be questioned at the police station or appear in court in another country, or if they fell victim to a crime in another member state. Of course, the extent to which common procedural guarantees have been achieved in practice is a different question. As it happens, I'm discussing pretrial detention in my criminal practice lecture with year ones later on today. An area where one can notice substantial variation between the UK and the EU, with pretrial detention being a domain where the UK generally fares quite well in comparison to our European neighbours, especially from the viewpoint of the much shorter length of pretrial detention in the UK. More broadly, common rules strengthen mutual trust between the judiciaries of different EU countries, making cooperation and mutual recognition of decisions, particularly in relation to the extradition of defendants from one country to the other, easier across the EU. So it's in this context that we need to discuss the European Arrest Warrant, the key mechanism for the extradition of defendants in the UK, as it applied in this country until the 31st of December 2020. It's in the same context that we need to examine the new surrender provisions in the trade and cooperation agreement that have taken the place of the European Arrest Warrant. So let's start at the beginning. What is the European Arrest Warrant? It's a simplified and expeditious surrendering procedure, important, simplified, speedy, expeditious surrendering procedure that had replaced previous, less effective extradition proceedings among member states, which were quite cumbersome, which were taking a long time, where sometimes there was political influence, and which often collapsed with the outcome that there wouldn't be an extradition in cases where there was a significant need to extradite an individual from one member state to the other. What does the European Arrest Warrant do more specifically? It allows a member state, the issuing state, to issue, naturally, a warrant that requires another member state, the executing state, to extradite to them, to the issuing state, a person who has committed a serious crime, so as to face quickly and with little administrative burden justice. For example, the UK could issue a European arrest warrant for the return of to France, so issue a European arrest warrant, send it to France or Germany or Poland or Greece, and to ask with that the return of a European citizen who might have committed an offense in the UK and been evading justice by being in France and Poland and Germany or Greece. The European Arrest Warrant was the first and most prominent instrument of mutual recognition in criminal matters adopted by the EU. What does that mean? That meant that a judicial order issued by one member state to another member state would be recognized by the latter, so the European Arrest Warrant sent to Poland, to Germany, to France, to Greece. It would be automatically, quickly recognized by these member states without further burdens, without formalities, without delay, unless certain grounds of refusal applied. I'm giving you the simplified version here. The European Arrest Warrant was a groundbreaking development in the area of freedom, security, and justice. Why? By signing up to it, member states were agreeing to surrender EU citizens, including, and this is very important, make a note of that, including their own nationals. So, Greece, if I was evading in Greece, they would be able, or they would have to, they would be compelled to, under the European Arrest Warrant, to extradite me back to England. Suppose suppose England had issued an arrest warrant for your lecturer here. So member states were agreeing to surrender EU citizens, including their own nationals, and you understand that politically that carries a lot of force and has ramifications to have to surrender your own nationals to another member state. That is generally quite difficult, and that can have a political cost at times. And to be able to do that with minimum scrutiny, not even spending a long time making sure that procedural guarantees are in place and that everything else is in place, but rather to extradite in the context of this European arrest warrant quickly and efficiently to another member state. And all that was based on the idea of mutual trust in the judiciaries and legal systems across Europe. How was that working more precisely? The idea that was underlying this radical development was that if a relevant judicial authority in a member state had reached the decision to issue a European arrest warrant, the UK legal authorities, for instance, it could be trusted. They could be trusted in another member state. So the Greek authorities or the French authorities or the Polish authorities could have trust in the ability of the UK authorities to issue a European arrest warrant on the basis of sufficient evidence and by following appropriate human rights compliant procedures. This ultimately allowed for the speedy execution of the European arrest warrant by the executing member state, which did not need to waste time further investigating the reasons supporting the European arrest warrant, unless again certain grounds for refusal applied. Now, commentators have pointed out that prior to the introduction of the European arrest warrant, the process, which was regulated by the European Convention on Extradition Act, which was going back to the 50s, was much slower and much more expensive. It tied up more government resources, left suspects at large or waiting in pre-trial detention, and left victims without justice for much longer periods of time. Here, speed is crucial. To be able to bring someone back to the country so that he or she face justice is crucial. It's exactly what the European arrest warrant was setting out to achieve. Alison Saunders, for instance, the former director of public prosecutions in the UK, described the European arrest warrant as 3 times faster and 4 times less expensive than the alternatives. According to EU statistics, nearly 18,000 European arrest warrants were issued in 2018 in 27 member states. Already the UK was not being counted in. And the most commonly identified categories were theft offences and criminal damage, nearly 3,000 European arrest warrants, fraud and corruption offences, nearly 2,000 European arrest warrants, and drug offences, 1,610 European arrest warrants. With stats from the arrest to the decision on surrender, it took an average 16 days to complete the extradition proceedings, the surrender under the European arrest warrant. That was when the person involved, the person in question, consented to their surrender, so it was voluntary. And then 45 days when the person did not consent. Even these 45 days was much, much shorter compared to what we had before. I must also add that the European arrest warrant is seen in the European Union as the most successful instrument of judicial cooperation in criminal matters in the Union, to cite from the website of the European Commission, which also highlights the following high-profile examples where a European arrest warrant had been successfully applied. A terrorist involved in the Paris attacks caught in Belgium, an attacker of the Brussels Jewish Museum arrested in France, a failed London bomber caught in Italy, a German serial killer tracked down in Spain, a suspected drug smuggler from Malta surrendered by the UK, a gang of armed robbers sought by Italy, whose members were arrested in 6 different EU countries. So reflect on that and ask yourselves the question, would that have been possible under the previous regime? And of course, the most timely and urgent question is whether the UK will retain capabilities to continue in the same path in the context of the new regime, the new surrender provisions in the trade and cooperation agreement. Let me now move on to highlighting how the European arrest warrant was different to traditional extradition proceedings, and that also goes in the direction of highlighting what were the strengths, what was so innovative about the European arrest warrant when it came into effect, and that will allow us to reflect on what it is that we might be losing by leaving that framework and initiating a new framework, which, as I said from the outset, does not leave some gaps open and is not going to be as speedy a process, commentators argue, as the European arrest warrant, or effective, not as effective a process as the European arrest warrant was. So it is really worth discussing in more detail how the European arrest warrant innovated compared to the extradition proceedings that were previously in place. This will allow us to reflect, as I was just explaining, what it means for the UK to have now departed from it post-Brexit in adopting a new system that may not, on the one hand, signal a full return to the pre-European arrest warrant status quo. As again, as explained, the new surrender regime has retained some of the advantages of the European arrest warrant, but it's nonetheless a system that will give the UK much less operational capacity in this area compared to what the UK had before. So compared to traditional extradition proceedings, so what was there before the European arrest warrant came into play, the European arrest warrant had, first of all, stricter time limits. The country where the person was arrested had to take a final decision on the execution of the European arrest warrant within 60 days after the arrest of the person. If the person consented to the surrender decision had to be taken within 10 days. The person requested had to be surrendered as soon as possible on a date agreed between the issuing state and the executing state, and no later than 10 days after the final decision on the execution of the European arrest warrant. Second, this is very important, a dual criminality check, i.e. whether the act in question was an offense in both countries. So this was no longer required for 32 categories of offenses. That was previously an important requirement in traditional extradition proceedings. You had to make sure that the offense that the person in question was that his extradition was being sought for, you had to make sure that the offense that he had committed, that the act that he had committed or she had committed was an offense both in the issuing state and the executing state. So the European arrest warrant did away with that. And as you can quickly observe, I'll reflect on, I'm sure that again increased the speed and effectiveness of the process. It made sure that extradition would be possible in many more cases where otherwise the dual criminality check or requirement would have stopped extradition. The only requirement in that respect that was in the European arrest warrant was that the act in question should be punishable by a maximum period of at least 3 years of imprisonment in the issuing country. So the UK, again, in our hypothetical, the hypothetical that we have been working on, the UK issuing a European arrest warrant to France or Poland or Greece, the offense in question should be punishable by a maximum period of at least 3 years of imprisonment. Which means that the European arrest warrant, there was a proportionality requirement. It should be reserved for the more serious cases and not the more trivial offenses. For other offenses, surrender might have been subject to the condition that the act constitutes an offense in the executing country. So anything less than 3 years, anything punishable by less of 3 years, then, as I explained, the requirement was that dual criminality was coming into play. Thirdly, the European arrest warrant did away with political involvement, so judicial authorities would now have to take full responsibility for executing the warrant with no political considerations involved. And that I must tell you by opening a quick parenthesis here, that has in recent years led to substantial jurisprudence coming from the Court of Justice of the European Union in relation to the fundamental question of whether the judicial authorities in question, for instance, in Poland, where you may know, where you will know, there has been substantial questions about the rule of law. The Court of Justice jurisprudence developed along the lines of the question of whether it was now possible to extradite someone to Poland. The question of whether we could still have faith that there would be no political involvement in these extraditions. And the Court of Justice of the European Union came short of stopping extradition to Poland in the context of this rule of law crisis. Interestingly, it has also found that prosecutors making these decisions, setting the extradition, the European arrest warrant process in motion in Germany, were not fulfilling the independence requirements. They found that there was a close link with the political institution there. They were hierarchically linked to politicians, the Minister of Justice, for instance, and so the process had to change, and prosecutors had to have less involvement, if any involvement at all, in the European arrest warrant proceedings. I'm closing the parenthesis here. The four key difference related to the surrender of nationals. So again, a fundamental difference, as I pointed out briefly earlier on. EU countries under the European arrest warrant could no longer refuse to surrender their own nationals unless they decided to take over the execution of the prison sentence against the wanted person. Finally, in relation to guarantees, the country that executed the European arrest warrant could require guarantees that, first of all, after a certain period, the person would have the right to ask for review, especially if the punishment imposed was a life sentence. And secondly, the wanted person could do any resulting prison time in the executing country, if they were a national or habitual resident of that country. There were also limited grounds for refusal. A country could refuse to surrender the requested person only if one of the grounds for mandatory or optional refusal applied. Mandatory grounds, first of all. Again, the foundational requirement of ne bis in idem. Ne bis in idem meaning that the person had already been judged for the same offense. If the person had already been judged for the same offense, then the executing state could actually say, no, we're not going to extradite the person. They have already been judged for the offense that you're seeking to have them extradited to your country. Secondly, minors. If the person had not reached the age of criminal responsibility in the executing country, then again, there wouldn't be extradition. And thirdly, amnesty. The executing country could have prosecuted them, and the offense is covered by an amnesty in that country. There were some optional grounds too, such as a statute of limitations in the executing country. That means that the time that had elapsed since the commission of the offense had exceeded the maximum period during which a prosecution could be initiated. Again, this is an area where there's much variation between the common law countries and continental, where such statute of limitations do not exist, as far as I know. And maybe Dominic can enlighten us if he knows of any cases where they do exist. But in Europe, they're part and parcel of criminal procedures. So with the less serious offenses, you have to start the prosecution within 5 years. Otherwise, you will never be, as a prosecution service, be able to do so. And with more serious offenses, you have a time limit of 20 years. And I'm just taking my examples from Greek law, but similar examples apply in other parts of Europe. Okay, so I'm concluding this part of the presentation. I won't be taking much longer, but this concludes that part of my analysis that related to highlighting and that aimed to highlight the intrinsic strengths that the European arrest warrant brought into play. It was a groundbreaking radical reform that has achieved speed and effectiveness. On the other hand, we should not dismiss the important human rights concerns that were raised in this area. So a lot of commentators were pointing out that despite the controls from the part of the Court of Justice of the European Union, and despite this idea of mutual trust, mutual recognition between the 28 member states, questions, important questions, serious questions, could still be asked about the extent to which specific procedural rights were protected in a coordinated way across these 28 member states. So, could the UK have faith, confidence in the right to legal assistance in Romania or Bulgaria or Hungary for that matter, or Poland in the context of the rule of law crisis in recent years? And so that was leading to the argument that the idea of mutual trust, mutual recognition, without spending time in the context of extradition proceedings doing more full controls of human rights compliance was a bit of an illusion, and that there were significant risks inherent in the European arrest warrant from a human rights and procedural rights point of view. But from the angle of effectiveness, of time spent, of not being confronted with significant administrative burdens, there is no doubt that the European arrest warrant was a very efficient mechanism in the fight against crime. So let me conclude that part of the presentation and now move on to where we are now. And before I do that, I will also quickly refer to the negotiations, the Brexit negotiations, and developments that related to the European arrest warrant. So during the negotiations, both the UK and the European Union appeared strongly committed to continuing security cooperation in criminal justice matters after the UK's withdrawal from the EU. And that is a reflection of the fact that this cooperation, as Dominic will know better than I do, given that he's been dealing, I'm sure, with such cases in practice in his Attorney General role. So that cooperation was effective, was a sophisticated framework of collaboration, and both the UK on the one hand, the other EU member states on the other, stood to gain a lot from this from having these effective channels of collaboration. So it was positive that in the negotiations started with both parties having the ambition to have a new framework in place. I would simply point out that perhaps they diverge somewhat as to the nature and scope of the new framework that they could build, that they could put in place. So the UK was indicating on the one hand that it wished to strike a new security deal with the EU, allowing it to sustain cooperation on the basis of existing EU measures. It has to some extent achieved this in the area of data sharing and police cooperation. Maybe Dominic will offer a reflection on that. But on extradition, the UK ambition did not quite square, I don't think, with the EU position that the UK would be a third country now outside Schengen after Brexit, and that as such, it would not be able to maintain the status quo. The status quo could only be reserved for member states fully complying with the EU acquis, EU legislation, EU jurisprudence to be more specific, and subscribing to that idea of mutual trust and the mutual recognition principle. As Michel Barnier said, for instance, at his address to the plenary session of the European Parliament in, let us go back to March 2018, it is not possible, it will not be possible to ask from the outside for mutual recognition of rules and standards, as that can only be based on trust, meaning common laws, joined up oversight, and a single jurisdiction. That's Michel Barnier, March 2018. He was equally categorical when speaking before the EU Agency for Fundamental Rights in June of that year, explaining that mutual trust and the European arrest warrant depended on the free movement of people, Court of Justice of the European Union jurisdiction and subscribing to the European Union Charter of Fundamental Rights. And the UK was no longer ready to accept any of those. The new agreement, the final part in my presentation. So part 3 of the Trade and Security Agreement covers law enforcement and judicial cooperation in criminal matters. Title 7 of part 3 contains the provisions on surrender, which replace the European arrest warrant. So that is the part that you need to examine in more detail after this lecture to understand the full extent, the nature of the new system that has now been put in place for extradition, for the surrender of citizens of other countries to the UK and vice versa. Let me concentrate on some key differences with the European arrest warrant, again to try to understand how far the new system can go in providing protection and in allowing the UK to continue in the same path of effectively and quickly extraditing suspects here and also extraditing others to member states in the European Union. So in terms of differences, perhaps the most important one is the reintroduction of dual criminality. In other words, the requirement that the offence in question must exist in both jurisdictions, both the UK and the EU, both in the country issuing the arrest warrant and the country executing it. This means that there will, by definition, be many cases where extradition will simply not be possible, whereas it was possible before under the European arrest warrant. The surrender provisions in the agreement provide, nonetheless, for the ability to waive this dual criminality requirement. So the UK or other member states could say, we're no longer going to apply that dual criminality requirement. I must, however, note that the provisions in the Trade and Cooperation Agreement on surrender reflect those that apply in the extradition agreement that the EU has signed with Iceland and Norway. And it is noteworthy that in the context of that agreement, only Spain, Slovenia, Lithuania, Romania, and with a more limited scope, Poland, only these 5 countries have waived dual criminality. So it may be possible to deduce from this that the vast majority of EU member states are not likely to waive the dual criminality requirement, and that this will therefore reduce, perhaps substantially, the scope for extradition in the context of the surrender provisions in the Trade and Cooperation Agreement. On that note, I must add that I found particularly interesting a comparative law observation that Gemma Davies, Dr. Davies, who's assistant professor at Northumbria, made before the Northern Ireland Home Affairs Select Committee on January 13th. She pointed out that in the case of Ireland and the UK, obviously the Select Committee was particularly interested in how the new surrender provisions were going to affect the relationship between Ireland, Northern Ireland, and the UK. So Dr. Davies pointed out that in the case of Ireland and the UK, the dual criminality requirement might not pose as big a problem as in relation to other member states. And that would be because both Ireland and the UK are common law countries. And there is, generally speaking, I quote, quite a large degree of alignment in their criminal law. But, she admitted, this will still likely slow things down, which naturally leads me with my comparative law hat on, comparative law expert hat on, leads me to think that in extradition proceedings relating to member states in continental Europe, where there will by definition exist substantial divergence between what is punishable under UK criminal law and what is punishable there, given the historic dividing lines that separate the common law tradition from that in continental European law, the dual criminality requirement has the capacity to emerge as an important stumbling block to surrender extradition, effective and speedy extradition in the future. So dual criminality is the first important difference between the new regime and the old regime, or the ancien regime, if I can put it this way. The second key difference is that states will be able to refuse to surrender their own nationals or only do so in certain conditions. Again, a fundamental difference between the new regime and the European arrest warrant. Countries that have applied this derogation in relation to Iceland and Norway are likely to do the same with the UK. If we take that as an illustration of how they might act in the near future in relation to the new surrender regime, which means that the UK might stand to lose the ability to extradite citizens from up to 8 countries and even 16 if it is not willing to return convicted nationals to serve their sentence, which means that this key difference could substantially frustrate the country's ability to do extradition and to do it quickly and efficiently in the context of this new regime. Third key difference: countries can refuse to extradite for political offenses. Fourth difference: the agreement introduces a number of human rights safeguards for those whose surrender is requested. So the executing country can now examine whether these human rights guarantees are satisfied before they proceed to extradition. Professor Steve Pearce of Essex Law explains that this could be general arguments drawing on national constitutional grounds. And Ireland is again an interesting example, because Ireland was not extraditing to the UK on national constitutional grounds for historic reasons, and that, we can go back to the time of the Troubles and IRA terrorism in the 70s. So Ireland was very reluctant to extradite its citizens, or more broadly extradite to the UK on national constitutional grounds. This had gradually gone away. This cultural and political resistance to extraditing individuals to the UK from the part of Ireland had gradually gone away with the European arrest warrant, given that Ireland and the UK were now part of the European Union. They had an effective framework which was based on the idea of mutual trust, mutual recognition. So that had gone away. But as Steve Pearce argues, these problems could now pop up again. This resistance, this constitutional law resistance might pop up again now that the UK is the third party. We'll have to wait and see. We'll have to wait and see what happens. Concluding observations. As in relation to other aspects of their future relationship, so too with extradition, the UK and the EU have avoided, with the trade and cooperation agreement, its surrender provisions more specifically, the significant damage that no deal would have caused. And again, it's a useful illustration of the importance of the work that politicians like Dominic and academics that we have collaborated with, NGO experts as well. It's an important illustration of the importance of the work that they have done in order to prevent no deal. And it goes to show the logic of what they were saying, that no deal would have been damaging in so many different ways. And extradition was going to be one area that would have been gravely affected had we not agreed, had we not had an agreement in place. Now, the new system is likely, I think, to prove much slower and much less effective than the European arrest warrant in practice, especially if the UK and the EU were to pursue separate paths in the area of freedom, security, and criminal justice in the future, which they are bound to, given that continuous alignment will no longer be possible as a result of responding to, adjusting to, accommodating EU directives, EU legislation, in other words, or common criminal offenses or common procedural standards, for instance, and in view of the fact that the jurisprudence of the Court of Justice of the European Union will no longer have the capacity to influence the development of criminal law and criminal procedure standards in the UK. The practical question also arises in that respect about whether EU member states will continue to prioritize arrest warrants from the UK. Professor Mitsilegas of Queen Mary notes, they might be hard-pressed to give priority to those arrest warrants coming from fellow rather than mellow member states. Some of them are mellow too. So the more the UK and the EU will be diverging in the future, the more complex it will naturally become to retain a model of close, speedy judicial cooperation between them. At a time when, interestingly, it is likely that we will be conversely observing a coming together of criminal law and criminal procedure in member states in the EU, and increasingly close and fast judicial cooperation between them. So they will be doing that, we won't, as perhaps is the natural consequence of having left the European Union. This gradual distancing of the UK and EU legal systems will, paradoxically in a way, also force them to pay more attention to human rights issues. So that's a positive aspect of the new regime. They'll pay more attention to human rights issues when executing arrest warrants in the context of the surrender provisions in the Trade and Cooperation Agreement. This is because the countries involved will no longer be able to rely on mutual trust and mutual recognition. To have that, as I explained, you need a coordinated development of different legal systems under the influence of the same sources of law, which will no longer be happening. They will therefore have to actively and closely scrutinize individual extradition requests in the light of procedural and human rights guarantees available in the country requesting the execution of a warrant, as well as alignment on criminal offenses, the dual criminality requirement. A final postscript here, a PS on human rights more specifically, because the above very nicely, I think, lead to a final observation. And I know Dominic has recently appeared in our select committee, one of our select committees, I think the Human Rights Select Committee, a joint committee on human rights, discussing the question of the future of the Human Rights Act, and so there is an interesting observation to make here in terms of how the Brexit negotiations on security may have affected or may affect in the near future the future of the Human Rights Act in the UK. So the point I'm making here is that Brexit may have, ironically, in a way, ended up saving the Human Rights Act and the continued operation of the European Convention on Human Rights in the UK, at least for now. Though at the same time, I have to say that at the political and institutional level, I'm still concerned about the direction that we're taking. And again, to briefly introduce you to the political context, you will know that David Cameron's government had previously committed to repeal the HRA, the Human Rights Act. Theresa May's government has committed to keeping it in place until Brexit was complete, whereas Boris Johnson's government, with the November 2019 manifesto, committed to updating the Human Rights Act. We'll still have to wait and see what that means precisely, but I can mention now that an inquiry looking into all this has been launched. Now, in response to all these developments, in response to these developments in the UK around the Human Rights Act, and in anticipating possibly the UK to further distance itself from the European Convention of Human Rights after Brexit, perhaps it was an innate fear that the European Union had. So in view of all that, and anticipating all this, the European Commission took the quite extraordinary measure of adding a sort of a guillotine clause to the Security and Judicial Cooperation Agreement, which would allow the EU to terminate the agreement if the UK decided to leave the security agreement. The EU would be able to terminate the security agreement, the extradition, including the extradition provisions, if the UK decided to leave the convention, or if the UK were condemned by the European Court of Human Rights for non-execution of a European Court of Human Rights judgment in the relevant area. And here I would encourage you, to be more precise, to look at Article Law General 3. So that is Article Law General 3, which states on which highlights the importance of giving effect to the rights and freedoms in the convention domestically, so that that may prove quite crucial in terms of providing protection to the Human Rights Act in connection with the security agreement. And then the other provision that you might wish to look at, we don't have the time for that. I'm conscious that I've taken more than I originally planned. Article Law Other 136, which relates to termination of the security agreement, and which provides that each party may at any moment terminate this part by written notification through diplomatic channels. And in that event, this part shall cease to be enforced on the first day of the 9th month following the date of notification. So there can be quick termination there, only within nine months. But there is also the provision that if this part is terminated on the account of the United Kingdom or a member state having denounced the European Convention on Human Rights, then this part, the the extradition provisions shall cease to be enforced as of the date that such denunciation becomes effective. So they will immediately cease to be in effect. The addition of this guillotine clause, this European Convention on Human Rights guillotine clause, sends a strong message, and I'm concluding with this, a strong message to the UK about the approach that it has taken on the convention in recent years, and went, in my opinion, in the right direction of making rights, human rights, European human rights, the European Convention on Human Rights and the Human Rights Act central to the security agreement. Thank you so much for your attention, and I'm sorry that I've taken much longer, I think, than I had originally promised. Sorry, Virginie. Sorry, Dominic.
Thank you very much, Dimitrios. You're completely forgiven for having taken a bit more time, because it was absolutely fascinating and it was also extremely clear. So I didn't know much about the European arrest warrant, and now I feel much clearer about it. So thank you for enlightening me, and I hope enlightening the cohort as well. And I found it particularly illuminating and thought-provoking, the fact that, yes, as you quite clearly pointed out, the loss of the European arrest warrant and the loss of expeditiousness of surrender somehow is also potentially a gain for human rights, potentially. So maybe one Brexit dividend there for human rights at least. So I'm quite interested by that, and I hope we can come back to this in the discussion. But yeah, that extremely interesting presentation. So thank you very much. And now I leave the floor to Dominic, who will take us to a little bit of the broader subject of judicial cooperation generally. Thank you, Dominic.
Well, thank you, Virginie, and thank you, Dimitrios, for that superb expose of the European arrest warrant, which I have no doubt is in many ways the centerpiece, or had been the centerpiece, of our relationship with our partners within the European Union in terms of justice cooperation, a very significant move forward. And as we've just seen, something which, as a consequence of leaving the EU, we are losing the benefits of and substituting for it, something which is certainly better than most extradition arrangements, but nevertheless isn't up to the standard of what we enjoyed previously. I should say also, perhaps the only comment I would make about Dimitrios's presentation is that the European arrest warrant, one should bear in mind, had long been quite a controversial topic. In the context of the United Kingdom, ever since it came in, it had been the subject of some criticism and concern that individuals might be extradited to countries in ways that were unjust. And though curiously, in the last few years, my experience of it was that the main criticism that was levelled at it was that it was clogging up our courts with requests for extradition for very minor offences. So it was pointed out, for example, that in Poland, rather bizarrely, prosecutors have no discretion as to whether or not to prosecute somebody. So if they decide to prosecute somebody for the theft of a sausage on the basis that the the sentence that can be passed on that individual will exceed the threshold limit, that person still had to be extradited, and that still had to go through a UK magistrate's court in order to bring it about. But that having been said, it was also noteworthy that Theresa May, who was tasked by David Cameron to carry out a review of the entire structure of justice cooperation, where some of my more Eurosceptic colleagues, as they then were determined to try to change the system, eventually came to the conclusion that it was massively in the interests of the United Kingdom that we should continue to be adherent to such things as the European arrest warrant and indeed the other areas of justice cooperation. Now, I thought that what I would try briefly to do this morning, because I want to leave time for a conversation, was perhaps just to widen the scope of the examination of justice cooperation from the EAW to some of the other areas of cooperation which have been affected by Brexit. Start, and I'm not going to repeat what Dimitrios has said, one starts with the concept of the area of freedom, security and justice, and of course underpinned ultimately by the creation of a number of institutions to bring that about, including Europol, Eurojust, the EU's Agency for Judicial Cooperation, the existence of attempts at harmonising asylum and immigration policies, the police cooperation, harmonisation of criminal law, and of course all underpinned by the EU Charter of Fundamental Rights, which, as many of you will be aware from my earlier lecture, that last year has been a subject of massive controversy in the United Kingdom as imposing rules that people didn't actually want, but of course was the necessary precondition, as Michel Barnier pointed out in the case of the EAW, to having a common set of rules which commanded confidence and a common set of principles which could be resolved by a common tribunal. Now, of course, our departure from the EU inevitably calls that level of participation into question. And the area where it has undoubtedly affected us the most lies in our ability to access databases. The EU has a large number of databases. Each serves a different purpose. It may be to catch criminals or to gather information on visa applications. Each database has one or more different legal bases depending on its purpose. Different parts of a database are used for law enforcement or to secure Schengen's external borders. That's involved different bases. And although the UK has never been a member of Schengen, we succeeded rather well in having the right to participate in the vast majority of Schengen-related measures, apart from not being obliged to let people through without border checks. So there's no legal base in the EU treaties for a non-EU, non-Schengen country such as the UK to access Schengen data. So one of the key areas in the negotiation was the extent to which the United Kingdom could negotiate workarounds which would allow us to continue to access this information, which has been repeatedly stated by senior police officers as being incredibly useful to providing security and crime prevention in the UK. Now, there's the second generation Schengen Information System, known as SIS2, a centralized EU database of stolen identity documents and wanted people. The database operates in real time and has been accessible to the police of member states and probably been the most valued tool by the police. And hitherto, the United Kingdom has participated in most of the Schengen's criminal and policing laws. The database allows participating countries to share alerts on law enforcement in real time. To give an idea of the scale of this, Deputy Assistant Commissioner Richard Martin of the Metropolitan Police, when giving evidence to MPs in July 2020, said that this system had been accessed by UK police 603 million times in 2019. The second system is the Visa Information System, VIS, a centralized EU database storing fingerprints and digital photographs of those applying for a Schengen visa. Well, because of our inability or unwillingness to sign up to any common form of oversight of these systems, the United Kingdom has lost real-time access to both of these databases. And I have absolutely no doubt that the impact of this will be considerable. It's true to say, I'll come on to this in a moment, that there may be other ways of accessing these databases through our continued participation in Europol and the liaison officers who are working there, but that is different from real-time access, because real-time access enabled a police officer who was stopping a vehicle on a road to simply key it into his computer and get the information flashed up immediately, and the same would apply to somebody doing border control. With some of the other databases, we have been more successful. There's a passenger name record database accessible to all EU member states, which is to exchange information about airline passengers travelling between the EU and third countries. It can also be applied to intra-EU flights, provides a legal basis to enable EU airlines to share data with law enforcement authorities and help prevent, detect and investigate serious and organised crime and terrorism offences. The effect is to enable the effect of the change, enable to require air carriers to transfer to the UK's passenger information units by the preferred push method. So long as that remains the case, the UK will retain access to vital real-time information about arrivals. So effectively, the United Kingdom has been able to negotiate a workaround in relation to that particular database. The United Kingdom has, however, lost access to Eurodac. This is significant as the absence of information about those who seek asylum in the United Kingdom, who've already become known to a third EU member state, will be material in whether or not their claims in the UK will be regarded as inadmissible under the new asylum procedures that the United Kingdom is introducing. Rather oddly, the Home Secretary has kept on assuring us that the United Kingdom will be much safer now it has restored control of its borders. But as Eurodac was one of the most ready ways in which one could ascertain whether somebody was entitled to asylum in the United Kingdom in the first place, the loss of this information will, I think, have an adverse impact on our ability to return individuals to other countries. Although it's also right to say that as we're putting out of Dublin III, we are in a situation where, unless we negotiate bilateral agreements, it's uncertain whether we're going to be able to return asylum seekers who fail their asylum applications to the country where they first made their asylum application in any event. There's also a PRUM systems database, which stores DNA profiles, fingerprints, and vehicle registration data, and we've been able to retain access to that. And we've also been able to retain access to the European Criminal Records Information System called ECRIS, which allows criminal records of individuals on national databases across the EU. So the picture in terms of the actual losses is mixed. My personal view is that, in fact, they are significant, and our disappearance from the Schengen database in real time will, I think, have a significant adverse impact. But of course, lurking behind that, there is also the wider issue, which is perhaps linked to what Dimitrios was talking about in terms of our adherence or continued adherence to the European Convention on Human Rights, which is the issue of data adequacy. Because our ability to access any of these databases or make use of them will clearly be subject in future to whether we are seen as being data adequate from the point of view of the European Commission, which currently extends that to the European Economic Area and to ourselves. Now, that may continue, but there are a number of straws in the wind which highlight some of the potential difficulties which may arise. Firstly, some of you may be familiar, in July 2020, there was the Schrems Judgment 2 judgment in the European Court of Justice. That invalidated all transfers of personal data on the basis of the Commission's earlier Privacy Shield decision from the EU to the USA, and transfers on that basis are now illegal under EU law. And the court stipulated stricter requirements for the transfer of personal data based on standard contract clauses. And this could have serious consequences for data transfers outside the scope of those standard contract clauses, such as the transfer between EU security agencies and non-EU agencies. Within the EU, data controllers or processors who intend to transfer data must ensure that the data subject to them is granted a level of protection essentially equivalent to that guaranteed by the GDPR regulations and the EU Charter of Fundamental Rights. After the 1st of January, all that includes transfers of personal data from the EU to the United Kingdom, particularly where there is any possibility that that data might then be transferred by the UK to another non-member state. And usually when you're talking of another non-member state, the anxiety at EU level is about the United Kingdom's security relationship with the United States of America. And the CGAU has confirmed that EU standards of data protection must travel with the data when it goes overseas. In addition to that, you've got the Privacy International judgment, rather piquantly initiated by David Davis when he was no lot the Brexit minister, and prior to his being so, he subsequently dropped out of this litigation, which was a reference on the UK's Investigatory Powers Tribunal concerning the legality under EU law of Section 94 of the Telecommunications Act 1984. That's about the way in which United Kingdom security agencies build up bulk personal data bases on individuals for national security purposes. And in the decision, the Charter required that account be taken of the importance, so the Charter has the right to privacy guaranteed in Article 7 and the right to protection of personal data guaranteed in Article 8, as well as the importance of the right to freedom of expression guaranteed in Article 11. Now, the transmission of traffic data and location data was carried out in a general and indiscriminate way, and therefore the judgment suggested that it would no longer be compatible with the EU law. That said, the Investigatory Powers Act has in fact replaced some of those powers with the need to have a judicial sign-off for access. And in those circumstances, the United Kingdom probably still remains within the compliance regime that the EU has set down. But as Dimitrios rightly pointed out, these are evolving areas, and with the possibility of greater divergence, there is the risk that in fact there will come a point where the UK is no longer seen as being compliant, and there is no way of resolving that by being within the EU, in which case you can't rule out the possibility that in fact we could lose access to all these databases and indeed our ability to do data sharing. As against that, I would simply make the point that the UK is, in security terms, a very big player within the European setting. So in practice, the amount of information, as I know from my time not only as Attorney General, but also Chair of the Intelligence and Security Committee, the amount of useful information which the UK can provide to its European partners is certainly as great as the amount of information which our European partners can supply to us. So it's very much in the interests of both parties to ensure that in fact this area of cooperation can continue. So all I'm trying to do, I think, this morning is just to highlight that this is a continuing area that will, I think, provide some further interesting discussions at future seminars that we might have. I haven't gone into this in complete detail, seeing the time factor. You may wish to go away and read this up in a little bit more detail yourselves. It is, I think, likely to continue to be a big issue. I might also add this, that of course the ability to share data with the United States by the EU is also in practical terms a massive requirement. And so it is at least arguable that if the EU is capable of exchanging information with the United States, it ought to be capable of doing it with the United Kingdom. I suspect we will see probably more third-party negotiations involving both the USA and the UK together negotiating with the EU in order to make sure that that convergence can be maintained, and so the common standards are sufficient to enable the transfers to take place. Now, that was what I wanted to add in terms of areas of security cooperation. The only other judicial area that needs just to be touched upon is about mutual recognition of judgments. That, of course, is a civil law issue, but there is absolutely no doubt that the ability to have mutual recognition of judgments and their enforcement within the EU, of which we used to be a member, has been of huge advantage to our justice system in a whole range of areas. At the moment, the future on this remains extraordinarily, very much in doubt. We are no longer, as a result of what has happened, able to benefit from what used to be called the Brussels I and Brussels II rules for mutual recognition of judgments, which were under the direct supervision of the European Court of Justice. We are out of them, and no, I don't think there is any suggestion that we're going to be able to go back in. That then leaves the Lugano agreements, which are not anything like as good as those of Brussels I and Brussels II, but nevertheless provide a framework which is in theory open to countries outside the European Union, as well as countries that are within it. But rather bizarrely, at the moment, the EU, unless it's happened in the last few days and I've missed it, has still not given its go-ahead, and it needs the approval of all the parties, to the United Kingdom joining or Lugano as a single entity. How that's going to play out, I don't know, but clearly the longer it goes on, the greater the difficulties. Now, there are some other ways in which you can get judgments enforced and recognised internationally, but they are nothing like as good as those. So I simply flag that up as another issue. And then finally, Virginie just asked if I would say a few words about the trade agreement. And I thought I might add a couple of words about Erasmus, which is one of the things which doesn't feature in the ultimate agreement, and is certainly of concern and interest to students, and also I think to be of concern to us all. First of all, on the trade deal and what's happened. The trade deal is in fact exactly what Michel Barnier predicted. For all the assertions of Boris Johnson, an immediate aftermath of the trade deal, that the United Kingdom, I think he described the trade deal as belonging in the patisserie department. This was about cakeism, of having your cake and eating it. Well, it may be in the patisserie department, but it has to be said that the patisserie is quite small and not necessarily, to my mind, very tasty. Because yes, it has achieved something which the EU has never done with any other country, which is to do a deal which is a trade deal for free trade without quotas or tariffs. And I think the without quotas is probably the more important issue than without the tariffs. That's something you can get. But as we have been seeing over the last 3 weeks, to have quota-free or tariff-free exchange of goods is not the same as being part of a single market. There are significant impediments to the transfer of goods, ranging from phytosanitary checks to the rules of origin and the need to carry out checks to make sure that the rules of origin are complied with and you're not exceeding the percentage of the rules of origin of parts which have to come from within the EU or the UK. And the fact that all that requires a very considerable amount of paperwork, which previously was simply not required at all. Now, the good news for the United Kingdom with this regulatory framework is that I suspect large entities like motor car manufacturers, Nissan, for example, who have considerable resources and can set up streamlined in-house systems for providing the paperwork and are exporting in bulk, probably will be able to manage this system and the impact on profitability will be minimal. But on the other hand, if you are, as we've seen in the last 3 weeks, a cheese manufacturer of craft cheeses in Cheshire, making Cheshire cheese, a limited amount of which you're exporting to top French restaurants as individual parcels and packages, you are going to be effectively prevented from doing this without an economic cost, which is greater than the margins of your previous profitability. And we simply don't know what the impact on that is going to be. But the evidence suggests that although some of the problems that we're currently encountering are teething problems, in practice, some of those problems are going to be permanent. And unless they can be factored in to increasing the price of the product, which is already happening. I noted with interest of some cheap wine being imported from Portugal at £4, sold at retail at £4.70 a bottle. It's very popular, apparently. Is now going to cost between £7.50 and £8. Question is, will people still buy it at that price? Then I think that there is going to be a significant impact. And some of these rules are being phased in so that when they are finally fully operational, their bite may be more considerable than what we have had hitherto. And of course, as we've just seen last week, when the European Union, which just like the United Kingdom government seems to have the capacity to lose its marbles from time to time, suddenly decides that under the threat of AstraZeneca's vaccines going outside of the EU, it might invoke protocol of the Northern Ireland Protocol to prevent their transfer from the Irish Republic into Northern Ireland. There are ways in which, if the parties wish to mess around with the free trade agreement, they can do so. And indeed, the free trade agreement is subject to review and could, under certain circumstances, disappear completely. So I just chucked those into the mix. Also right to point out that services are currently not covered at all. And I think an interesting issue legally and economically is whether, in fact, over the course of the coming 2 or 3 years, there is any shift in the ability to provide services. Speaking personally as a barrister and having been part of the Bar Council's working party on future relations, we are facing a situation where, as things stand at the moment, the ability of a UK barrister or solicitor to take a flight to Paris and go to Paris in order to give legal advice for 3 or 4 hours on a subject of English law of which he may have expertise, as things stand at the moment, looks as if it may be subject to a visa requirement. And that is an extremely unsatisfactory state of affairs. And the same, of course, will apply to a whole range of professionals. And that's why, of course, musicians have suddenly discovered that if you're going over because you've been invited as an orchestra to go and give a concert in Paris, you will find that you're going to need a visa in order for that to take place. All, in my view, thoroughly undesirable, but I'm afraid the consequence of particularly the Home Secretary's obsessions over trying to restrict immigration into the United Kingdom. Finally, in my list, Erasmus. Despite what Boris Johnson had promised, we are not going to stay in Erasmus. Instead, the government seems to have decided that it wishes to use £100 million to bankroll a new Turing scholarship, which would enable UK nationals to go and study in foreign universities around the world. Why has this happened? Well, I have to say, I think it's a mixture of money and a certain amount of mean-mindedness, and I think also short-sightedness. The difference between the Turing Scholarship, which is the UK pays 100 million to enable, it believes, up to 35,000. I think it won't be anything like that figure, actually, because that works out at only about 2,200 per person. The UK pays money to enable UK nationals to go and study abroad. The foreign countries are expected to pay themselves for their own students to come and study in the UK. The Erasmus system was different. This was a pooled system within the participating countries, which meant that countries paid into that pool, and out of that money came both the money to pay for UK nationals to go and study in Europe, but also for European and other participating member nationals to come and study in the United Kingdom. And because study in the United Kingdom is so popular, it was inevitably biased in favour of EU citizens, or those who are other places like Norway participate. So to give you the figures, I think it was 17,000 British nationals going to study around Europe and 32,000 European nationals coming to study in the United Kingdom. But then I thought that one of the points about turning United Kingdom into a global player was that soft power, one of which is our higher education system, would be thought to be a good place in which to invest our money. But for reasons which I don't understand at all, the current government seems to have decided to opt for a much narrower approach, which I'm sorry, and who knows, perhaps they will be talked out of it because there seems to be some opposition to it. So I hope I've now fulfilled Virginie's request to do an oversight, nothing like as detailed as what Dimitrios did on the European arrest warrant, but I hope providing some overview of where we are. And now I think we're both going to be very happy to answer questions for as long as you wish to ask them. Thank you.
Thank you so much, Dominic, and thank you so much for, as ever, a very insightful presentation, and also for having covered such a broad range of issues, which has spurred many, many questions, I'm sure. And I found particularly intriguing that the complexity, the fact that you highlighted the complexity of the picture that is emerging from the point of view of judicial cooperation, security cooperation, and data sharing in particular. And really, I found intriguing the fact that the UK retained access to some databases, but not others. And it seems a bit, why? I mean, how did that happen? That it's such a mixed picture. And yes, I was quite intrigued by that. But yes, thank you so much for covering such a broad range of issues. But I don't want to take the floor too long because I'd like the students to be able to chime in and ask their own questions now. Thank you.
Right, just to answer you, my impression, and Dimitrios may know the answer to this better than I do, but I think the different databases may relate to the extent to which it was cooperation in terms of free movement between the United Kingdom and the EU. So the ones where we retained access to the databases were essential, well, not essential, but very, very important bilaterally, in order to enable that movement to take place, because passenger name records, for example, are essential when people land at airports. But the ones which are simply the shared databases for crime fighting and counter-terrorism, the real-time access is gone. Now, as I say, in fact, it will still be possible, I think, to get access to the information, but what you're not going to get is that instant response. And now that police are completely computerized, that is a serious loss. I mean, 603 million hits on a database in 12 months by your law enforcement authority. Yes, you can get that information by going to your liaison officer at Europol, who with permission will then access the database and may be able to provide you with the information, but it's not the same thing.
May I add that similarly, the UK has been operating the European arrest warrant very, very effectively.
Yeah.
Perhaps the two issues that are interconnected: the sophisticated operation of relevant databases and wider observation about the UK being a strong partner in the security relationship, perhaps enabled the UK to also use the European arrest warrant effectively. So. Whether the capacity will still be there to do that, to continue to lead the way in terms of both sharing or accessing information and extraditing suspects to the UK and conversely from the UK to Europe, whether that is going to continue is a very complex question. And of course, as with everything in the new trade and cooperation agreement, we will have to wait and see what particular shape this relationship takes. I mean, Dominic made an important observation about the pragmatics of all this. The fact that the UK is an important player might weigh more heavily in the balance vis-a-vis the constitutional need to ensure alignment of procedural and human rights guarantees. But I suppose there will come a time when perhaps we will either need to find effective mechanisms for rapprochement, or it will no longer be possible to cooperate in this way. This is what I'm taking away from Dominic's presentation. Again, we have maintained part of the status quo, but not everything. We are in a worse position than we were before in terms of data sharing, and importantly, at the same time, about our capacity to continue in the same way in the near future. And I think with all this, we have to think, now we're still more or less in the status quo, but think about forward down the line, further down the line, 5 years from now, 10 years from now, 15 years from now. I mean, we've been asking in a different context, in a different debate with EU citizens' rights. People are perhaps reassured now about the settled status and some protection of existing rights, and the fact that they're just coming out of a pre-existing situation. But I don't know, there are also significant concerns about whether that alignment between UK citizenship rights and settled status rights, where they will be 10, 15 years from now, and how we can make sure that we avoid abuse of power or people being suffering damage simply as a result of mistakes is a different question, and it's a challenging one.
Thank you, Dimitrios. I saw that Mohammed had a question to ask earlier. Mohammed, did you want to come in?
Hi, good morning, everyone.
Good morning.
Good morning.
Two questions for Dominic. My first question is, does Sanjan countries have access to UK criminal database at this moment? And my second question is in regards to invoking the Article 16 by EU in recent days. And obviously, we all know that the UK or EU can act unilaterally. But what could have been the effect on the Good Friday deal if it was actually invoked by EU?
Right. Just on the first question, the United Kingdom, the United Kingdom shares data, although it doesn't go into the deep. The United Kingdom either shares data under a legal base, or there are exchanges of information between security agencies for the purpose of counter-espionage or counter-terrorism. And all countries do this. This is a bit of a grey area. It's not for the purpose of law enforcement, although it may ultimately turn into law enforcement. It is exchanges of information. And arguably, as it's national security, it falls outside of the terms of competence of the European Union, Although the European Court of Justice is not like that one little bit. It's quite an interesting area. Even with the UK outside of the EU, it is a continuing area, I think, of controversy. It'll be interesting to see how the French government respond if the EU, the Court of Justice of the European Union, they weren't at all pleased with the Privacy International judgment at all in France. And indeed, any country which has substantial national security resources will be troubled by it. As matters stand at the moment, and all I can really say is that the UK has a sharing agreement on a large number of things with its Five Eyes partners, namely the United States, Canada, Australia, and New Zealand. This is the result of a treaty made in the 1940s, and the EU has always been concerned as to whether there are transfers of data that might originate from the EU, which are being transferred to those partner countries. But I think it's right to say that this is not a matter which has ever been finally resolved. Clearly, there may be transfers of data or information between the United Kingdom and other third countries under bilateral cooperation agreements, but they're not at scale. And I don't think that's what, and I'd be interested about Dimitrios's view about this, I don't think that's what the EU was particularly concerned about, the Court of Justice of the European Union. The point at issue, and I think the key point on this, is that as a result of being in the EU and the participation and the participant in the EU's judicial cooperation and law enforcement pillar, we were entitled as of right to receive certain information, and it's that information which the EU is now trying to restrict, irrespective of where or it might subsequently go. I hope that answers the question, that question. As for your second point about Northern Ireland, if the EU had carried out its threat, then I assume it would have required the Irish government to put police or border officials on the Northern Ireland border to check that cargoes of AstraZeneca vaccines were not accessing Northern Ireland via the Republic. For that matter, one must also assume that they would be having border checks at Calais and Hook of Holland to make sure that AstraZeneca consignments of vaccine were not going into the United Kingdom at all. So actually, the EU's behaviour was wrong on two counts. One, it was wrong because it was invoking a right to restrict free trade with the UK generally, without, in my view, a good or sufficient reason to do it. But secondly, and even worse, it was doing it in the context of Northern Ireland and creating the very hard border that the protocol was designed to prevent from happening, because Northern Ireland is entitled to be in the single market of the European Union. The Commission should have done this without even consulting the Irish government. It shows that for momentarily they'd completely lost their heads. In any case, something says to me as a lawyer that what they were planning to do would have been ruled to be unlawful by the Court of Justice of the European Union, because it may be very inconvenient that AstraZeneca are exporting vaccine out of the EU to the United Kingdom to honour a contract made with the United Kingdom. But as long as that's within contract law allowable, I'm not sure that the EU has the power to prevent that from happening. And if there is a breach of contract between the EU and AstraZeneca, because AstraZeneca is not supplying all the vaccine that had been promised to the EU, I'm not sure that's a matter where the EU is entitled to invoke its state powers, as I would describe it, rather than suing AstraZeneca for damages or going to court and getting an injunction. To act unilaterally in that fashion even if you feel there's a national emergency, is, I think, a violation of a basic principle of the rule of law. The state doesn't suddenly take over control, effectively nationalizing AstraZeneca and saying we are going to decide where your vaccines go. So it raised some very profound issues. And this is why I don't think it lasted more than about 12 hours before reason prevailed and somebody within the European Union pointed out that the Commission was saying things that were extremely flawed and also fundamentally wrong.
Let alone, if I may add to that briefly, that the inordinate behavior from the part of the EU was very much out of line with their coordinated effort over the negotiations period to protect that border. I mean, they made it one of the three key initial questions that had to be answered before we could move forward and have a trade agreement or start negotiating a trade agreement. The Northern Ireland border was one of the introductory chapters that had to be agreed upon, and you know, it was one of the key areas in the withdrawal agreement. The idea was that there couldn't be progress unless the three foundational matters: the divorce bill, the rights of EU citizens in the UK, and conversely the rights of UK citizens in Europe, and finally the Northern Ireland and Ireland border were resolved. So I don't know. I'm preferring to place emphasis on the fact that for over 4 years they played an important role in safeguarding the border, as opposed to this error of judgment, no doubt, that lasted something like 12 hours, as Dominic mentioned.
Thank you.
Any more questions from the audience? Okay, can I just take this opportunity to ask a further question on this question of the export bans? I am afraid I have to admit that I haven't read the Trade and Cooperation Agreement in enough detail to know the answer to that question, but I'm assuming that under EU law or even under WTO law, the EU could impose an export ban on the grounds of public health and protection of the life of humans under Article 36 of the EU or under Article 20 of the WTO agreement. So I don't know, don't have the details of the equivalent in the EU-UK trade agreement, but is there such a basis for the EU to do that in relation to the UK? As I assume there must be, because if there is one in the WTO on which it can do that, and within EU member states themselves under the TFEU, surely there is an exception of that nature in the EU-UK agreement. So I was just curious about whether any of you know about those provisions at all.
I don't know if Dimitrios does. I have to say this is a rather big agreement, and I'm not conscious of it. But I agree with you. You'd certainly expect to find such a term, but normally you'd expect that term to apply to stopping the import or export of goods that might be unsanitary, or it raises a very interesting question, which I don't know the answer, but perhaps we should go away and have a look at this.
Yes.
As to whether you are entitled to say that stock being produced in a particular member state is so vital to the interests of the European Union as a whole that you are going to prevent its export in a time of emergency, even though the company manufacturing it is under a contractual obligation to supply it. It's possible that such an override exists. It's certainly the sort of override that one would assume to exist at a national level. It's a slightly surprising thing to find at an international level with an organization, or perhaps I shouldn't call it an organization, that was supposed to be the term of abuse used by Lord Frost when he was negotiating with Michel Barnier, but towards an entity like the EU, which of course does have some state-like qualities about it, but only in a restricted way. It may be that Ursula von der Leyen was absolutely right, and she thought that this is a power that we do have. But of course, that power would still be subject, would it not, to the European Court of Justice of the reasonableness, because there's also the right of AstraZeneca in all this, and ordinary contract law, which raises some very interesting questions. If a company is in difficulty observing its contractual terms to party B, is party B entitled to enforce the contractual terms by preventing it from fulfilling its contractual obligations to party A, with whom it concluded an earlier agreement? Discuss. I don't know, Dimitrios, if you know the answer to that.
I don't know the answer to that. I don't think. But I was thinking that from a wider angle. Isn't this an illustration? This temporary fallout between the EU and the UK, which lasted, as we said, a few hours, and by the evening was resolved. Isn't that also an illustration of this new environment, the new phase in our relationship with Europe and the EU's relationship with us here in the UK, an illustration of the fact that when push comes to shove, the EU will no longer put British interests first, right? No. They will put their own interests, they will prioritize their own interests. And okay, we all accept, everybody here accepted, despite where they were coming from, that the EU was wrong in this case. It was exaggerated action that they were taking, or that they were suggesting they might intend to take. But on the other hand, there will be many other contexts where we will be faced with similar circumstances, and there will be a legal basis, and they will put the rights of the European Union first. I mean, that is what being in the union, operating from within the union, actually is about. I mean, the 27 member states, in relation to COVID more specifically, they have decided to give the European Commission the power to decide, how they will be protecting the health and public safety in their own member states. So. I suppose the EU Commission has a duty to put the interests of life and limb and health in the 27 member states first.
Yes, I don't disagree with that. They clearly they don't have an obligation to the United Kingdom, except I suppose to observe the terms of the treaty, and they're entitled to the terms of the treaty as they think best. But I'm quite interested in the relationship between the EU, the Commission, and AstraZeneca as a supplier located within the EU and manufacturing, about the right to interfere with AstraZeneca's commercial contracts. But then, as I say, there was some evidence that AstraZeneca were in breach of their deal with the EU, because they were saying that they could only supply 25% of what they had previously believed they would be able to provide.
It's also a reflection of different cultural and attitudes between the UK and the EU. The EU is seen by some of its critics, not least, as much more interventionist, compared to the UK when it comes to the free market, and so perhaps all that was in play here as well. So we'll have to wait and see. On Erasmus, I thought your reference to Erasmus was of great interest. I just want to add a dimension that we in Britain and Europe have researched and been quite active upon in recent months. So with my colleague Dr. Dagmar Myslinska, who teaches contract law in year 1, immigration law in year 2. She led on a report on immigration that was published in October or beginning of November, and so one of the points, one of the areas that we were looking at was also the access of EU students in the UK after Brexit. And one area that has not received sufficient attention. I mean, I was pleased that Erasmus has received sufficient attention in terms of those responding to the fact that we were not going to have it. It was a demonstration of the value that the Erasmus program has. You had all these personal stories about how people had benefited from that. But the aspect that was completely under the radar and continues to be is the fact that the EU citizens, EU students, will no longer qualify for home fee status in the UK, and they will no longer qualify for access to state government-backed loans to study in the UK. And that, to put it briefly, to put it quickly, actually means that in practice, a lot of them, a great number of them, will no longer be able to come to study to the UK. Maybe students from France, from Germany, perhaps Spain, the Nordic countries, perhaps they will still have the financial means, the independent financial means to do so. But for a student from Cyprus or Greece or Romania or Bulgaria or other parts of Eastern Europe, it will become impossible. That's the evidence that we have got from this country for them to come. And I'm saying that not that the UK has a duty per se to provide financial support to the students, but in terms of the cultural capital that we're gonna lose, we're gonna miss out on, that is going to be substantial. I mean, Virginie and I are just illustrations in our domestic local environment here of students who have benefited from quick access to the UK higher education system, be that in the context of Erasmus or access to postgraduate studies and perhaps doctoral studies in the UK. And all that is going to go. All that is going to go. It's not going to be sustainable. I don't know about the extent to which it's going to be sustainable to send our own students to Europe in the context of the new program that you've referred to, Dominic. I think it's not going to be to the same extent. And also, yes, the UK, perhaps the system was balanced more heavily towards EU students coming to the UK. But on the other hand, did you mention, Dominic, 17,000 UK students traveling to Europe every year? Was that the figure?
That was the figure I picked up. Yes, I went away and checked this. Let me just go and see if I could. Yeah, 17,000 in and out, and the numbers coming in. Yeah,
but in terms of the number of students, I was thinking, as an overall figure, the number of students from one member state going across to Europe, and we know that is a reflection of the cosmopolitan nature of the British, and that unfortunately will no longer be possible. It's going to be very, very difficult for EU students to come here and pay 17,000, 80,000 pounds compared to what they were paying before, and much more difficult for our own students, for UK students, to travel to Europe. It's very frustrating. I mean, you could see that in the reaction of the public. It didn't make any sense at all. Why, we managed to keep other viable, important elements of our relationship with Europe. Why did we have to do away with that?
I agree, and I wouldn't completely despair on this point. Admittedly, your point about the funding issue and the money, I don't think that is readily solvable. But I do detect, talking politics for one moment, that there are quite a few of my Conservative past colleagues in Parliament who are very unhappy at the decision over Erasmus. Partly, quite apart from anything else, because at the last, they kept on going around and telling their constituents, including students, that the Prime Minister had promised it was going to be maintained. So they're not very happy about it. And I think it's at least possible that the government might be persuaded to change its mind on this.
I thought that Dominic's observation on the loss that it represents for the UK in terms of soft power and that is absolutely apt. It's really a short-sighted decision because the UK will lose some influence as a result. And I think there is a trend that is already emerging with that. I've just heard that the UK is not going to put forward a judge for the ICJ. And that is, again, currently the UK does not have a judge on the ICJ. And that was unprecedented for the I know it's getting a little bit out of the conversation in terms of the UK-EU relationship, but it does flow from that. The fact that the UK currently does not have a judge at the ICJ, I think, is because of Brexit, because the UK is sort of starting to lose its influence, and since the United Nations had been in place since 1945, the UK has always had a judge on the ICJ, and now it's not putting forward a judge for the next round. And that goes to it all plays in the same sort of arena with the UK having this diplomatic soft powers that it has been excellent at and now seem to be sort of receding a little bit, which is a shame, definitely.
I agree about that. I have no doubt at all that our loss of our ability to get a judge onto the ICJ. On the last occasion, we pulled out at a late stage and said that India should get it, but it's quite symptomatic of loss of influence. There may also be another element in that, which is the advisory judgment in respect to the Chagos archipelago, which is a problem for the United Kingdom, even though it's an advisory judgment, because I think the UK has made absolutely clear that it doesn't intend to go along with it and disagrees fundamentally with the conclusions of that judgment. But of course, in terms of then putting another judge up for the ICJ, it makes it slightly more difficult and may simply have led the United Kingdom to take the view that even if we put a judge up, we're not going to get the judge elected.
Sorry to have detracted a little, but yes, the Erasmus point made me think about the UK's general influence diplomatically and on the point of view of international relations. So, yes. Before we wrap up, it would be nice to hear more from the students.
We have confronted them with a range of technical questions, but I see Fabian is about to come in.
Yeah, I mean, thank you so much, both of you. That's been incredibly informative. It was a lot to keep up with. It was very, very informative, very, very interesting. Thank you so much. I just had a comment. I mean, I had a couple, but I mean, mostly just on the note that Virginia brought up about what Dimitrios was talking about, the European arrest warrant, in that it is a little bit interesting that a slight rollback from that will amount to a slightly more acknowledgement of people's human rights, in as much as the ease of expedition isn't there so much anymore. And I did also want to just comment on you were talking about the dual criminality as a stumbling block, but the fact that we're talking about the fact that this is used for more serious crimes. I mean, aren't these more serious crimes recognized across the EU anyway? Does it really pose as a stumbling block? And yeah, that's pretty much it. Really, thank you.
Thank you. If I may take this question, Fabian, thank you very much for that. Can I start with the dual criminality point? Which, I mean, effectively, to provide an adequate, informed, detailed response to that, one is required to have comprehensive understanding of the specific criminal law legislation, criminal law offences applying across the 27 member states, and of course I cannot make a claim to such expertise. On the other hand, I would say that. Your gut feeling, if I can put it this way, about the fact that the more serious offences are possibly, we're going to come across them in both the UK and the EU. I think that's correct. In terms of common offences, in terms of what is usually the bread and butter in common criminal law. But then perhaps when you start to dig a bit more deeply and look into more specific, more idiosyncratic offences, I mean, think financial crime, for instance, think counter-terrorism, and how there is scope for divergence in these areas. I mean, different countries often take different approaches, some going further than others in criminalizing complicity, for instance, or preparatory acts, just to give you a couple of illustrations of activity that might perhaps come outside of that core area of activity where indeed, you are right, that most countries will be punishing the same offenses. So I think the dual criminality element is not going to stop extradition as such, but might significantly delay or deter, the capacity to do it effectively. I'm not saying it's going to bring the whole system down. I don't think, but there will be many cases where you were previously as a country able to do extradition, and now you will no longer be. On to take your first question now, second, I'll just say that I probably need to qualify somewhat the observation that I made about this new agreement, ironically requiring us to place more emphasis on human rights. I mean, it will. But the fundamental difference, I suppose, if I can go deeper now, is that we will have to do that. I mean, the judicial authorities with responsibility for these decisions will have to do that on an ad hoc basis. So when an arrest warrant comes in for Dimitrios or Virginie or Dominic, they will have to look into the specific procedural guarantees applying in this case and in relation to the two jurisdictions involved. So it's in that ad hoc context where the emphasis on human rights would be placed. However, in the European arrest warrant framework that we had before, the effort to come together in terms of human rights protections, procedural rights, is supposed to, at the very least, be happening all the time. So the 28, before the 27 member states now, are supposed to be working together in giving shape to common criminal offenses and conversely to common procedural protections. Especially since 2009, 2010, there has been an increasing realization of the fact that the 28 member states then had to have much more communality in terms of the defense rights, procedural protections. This was also in line with jurisprudence that was coming from the European Court of Human Rights, which led to a number of directives on the right to translation and interpretation, on the right to legal advice, on the right to silence, on the presumption of innocence. So, to put it simply, because you're doing all that as an EU, you're doing all that work, you're bringing your criminal procedure and criminal justice systems together anyway, there isn't so much need to do that on an ad hoc basis when it comes to the extradition situations. That is the principle there. So you're still looking into human rights, but at an earlier stage. That is just putting the problem in a generic way. And in reality, you will still come across the problems that Dominic referred to, that you will still have many cases where we felt in the UK that we were extraditing defendants for conduct that had not been sufficiently investigated. I mean, Dominic, you mentioned there the fundamental difference between common law, especially the UK law, and continental criminal procedure, where in continental criminal procedure, surprising though it may sound, we did the lecture a couple of weeks ago on prosecutions, there is this principle of legality, which more or less requires the criminal prosecution service there to initiate prosecutions on the basis of very little. Of course, that again can be explained on the basis of the fact that you then have a much longer period of time and opportunity in the pre-trial, in the more detailed pre-trial investigation phase, to stop somebody from being taken to trial. But I won't go into any more detail because I think we will lose focus here. But thanks so much for being well spot on in relation to both questions.
Thank you very much. I think we are reaching the end of the session. So I would like to take this opportunity to thank Dominic and Dimitrios very much for having joined us today and for having confronted us with such interesting questions on the relationship between the UK and the EU that is now starting to take shape. And I'm sure this is a conversation we'll have to come back to maybe in a year's time to see how things have evolved on the basis of this very initial assessment. But thank you so much for being with us this morning and for such interesting presentations. Thank you.
Thank you. Great pleasure to do it, as always.
Thank you so much. Bye-bye.
Thank you, Virginie and Dominic, wherever. So grateful.
Goodbye.
See you soon. See you soon, both.
Bye.
Thank you.
Bye.